Good morning and welcome to the David and David on Real Estate podcast. We are back at you with discussing more legal precedents on episode number 98. And of course, David Gorski in the house. Welcome back, everybody.
Yeah, great to be back. And last episode, we were talking about a case called Bazin, and it which wasn't a real estate case, but it raises this legal principle and concept of parties to contracts acting in good faith when in their dealings, and then how that relates to real estate transactions. And then there was another case called Callow and Zollinger that sort of followed that. And again, it wasn't a real estate case directly, although there was some real estate behind it. It was really about companies to a contract. There was property management involved, and then rights to renew those contract, and they weren't, and they sued each other. And the again, it was an issue of, can we rely on the strict contract that gives certain rights, or do we have to look at the facts and what the parties did behind the scenes? And if they weren't acting in good faith, do they lose their rights to rely on their strict contractual rights? So that's where we are. But now today we're going to actually talk about a real estate case.
Yeah, very exciting. And this case kind of takes all those principles and puts them into action, because the courts have really taken a look at the precedents and said, well, this not only applies to the buyer, but it actually applies to all parties in the transaction to act in good faith and to fulfill their contractual obligation, which is to bring the transaction to a close.
Right. So the case that we want to discuss today is called Moore and a numbered company, which were the plaintiffs. But this was a Court of Appeal decision in Ontario dealing with an actual real estate decision. And the simple facts, which are sort of important here, they signed a standard type of agreement of purchase and sale, that has a clause in it that we've talked about, a few times in our podcast. So the time is of the essence. So that means that, if there's any dates and times referred to in the contract, those strictly have to be adhered to. So the time for the irrevocable date, the time for any conditions, the time for the closing date, obviously the time for your title search, you have to strictly adhere to those, otherwise you're in breach of the contract. But here is a case, the transaction is moving towards closing in the normal course, but on the day of closing, the buyer's solicitor wasn't able to deliver the funds by 5 o'clock on the day of closing. Now, the facts behind the scene, this happens to be a COVID situation when this came up, when parties were everybody's experiencing difficulty in getting funds transferred on time. Banks had reduced hours, et cetera, as we can all remember what was going on during the pandemic. And this was just a classic example of that, where the transfer was in the works, but they couldn't actually get it transferred to the seller's lawyer in time. So the buyer's lawyer had money, was in the process of transferring it, but couldn't get it transferred by 5 o'clock. And the seller took a strict position. Hey, time is of the essence. You didn't get us money on time. You're in breach. Deal's dead. Goodbye. We're selling to somebody else. And obviously there must have been some advantage to the seller to try and resell the property to somebody else. So that's basically the facts as I understand it, David.
And very interesting, because the buyer's lawyer communicated nonstop with the seller's lawyer that they have the funds, that the buyer has an intent to close the transaction, that they want to close the transaction, but there was, some sort of obstacle with the land transfer system, whether it was a timing issue, but not, throughout the day, the two lawyer offices were communicating. They communicated that they have funds, that there is an intent to close. And the seller's solicitor took the position, well, we didn't receive the funds at 5 o'clock. You're in breach. We're canceling the transaction. We're going to take your firstborn, and this transaction's not happening. Now, when this went in front of the court system, the judge looked at the case and said, well, the seller really hasn't acted in good faith. because the buyer did absolutely everything they possibly could, including delivering funds and trust in his seller's solicitor account. So there was every evidence that the buyer acted in good faith and wanted to close. It was just outside the realm of possibilities. So the seller has to take an equal position and really meet the buyer halfway and move towards the successful completion of the transaction. So they can't cancel the deal on a technicality, which I think it reinforces this whole concept that we were talking about in a previous episode, where both parties have to act in good faith and bring the transaction to a close. And David, I know your office is really big on this. You guys are really big on bringing the transaction to a final close, making sure that we don't cause problems where there are no problems, and really furthering the transaction to make sure that both parties are working towards that final completion of the contract, which is what we want to see.
Right. And in this case, like in any case, you have to look at what the actual facts were. And there was no legal issues between the parties. There wasn't something going on in the transaction where one party was saying, I don't want to close, or I'm not sure if I can close, or taking any legal positions. This became strictly a timing issue. And a lot of it, innocently caused because of pandemic issues, which people couldn't necessarily contemplate even entering into the contract. And it just the banking took time. So here the buyer's lawyer had money, was able to communicate to the seller, I've got money, but I can't, but just the transfer to your trust account isn't going through. But here's evidence that I have it. We want to close. We're ready, will enable. Documents have been signed. Everything's been exchanged. There's no issues. It's just this timing issue. So, and the facts go on. Like the next morning, the buyer's lawyer transferred the funds to the seller's lawyer's trust account. So there's no real loss or damage to the seller. They're getting exactly what they were expecting to do when they signed the contract. So when the courts look at this, they're saying, no. Like, there's a duty on you as a seller to act in good faith. You weren't asked for an extension for a month or for a week or for a day, even on unreasonable terms. You have no loss to you. You signed a contract to sell the property. The property was sold. You got all your money. There's no reason to rely on the strict interpretation of the contract. So it reinforces this concept of parties have to still act in good faith. They can't look for a technical default and rely purely on a technical default in order to gain an advantage. Okay. And that's a really important concept. So in our office, we're very mindful of this concept of good faith. So, we're involved in negotiating extensions all the time. And we just did one over the last few days where these issues came into play. We're on the seller side of this one. Everything, our client's ready to close. We're all good. The buyer can't get their mortgage funding together and tell us on closing they can't get their mortgage funding together and ask for an extension. And then we grant terms of an extension. Now they can't close on the extension date and they're asking for further extensions. So in our negotiations with them, even though we could take a strict position, you weren't ready, willing, able to close, we're going to sue you, we're going to sell to somebody else, we do all that, but we're still have to make some effort to act in good faith to figure out if they do have an ability to close. Then we have to see if we can come to terms with that, protect our client, make sure they're covered for all their costs, but make sure that the evidence will show in the facts that we negotiated in good faith to try and get this done. So even in what we're requesting as extension terms, we have to try and show that we're not asking for onerous, unreasonable things. And maybe there's some give and take in our negotiation. Yeah, they balked at certain points in the extension, and we gave into that, and we wanted other things because we have an ability to show a judge down the road if we have to that we were always acting in good faith, trying to see if there's a way to get the transaction done instead of just relying on our legal principles.
Yeah, you actually took my question out of my mouth, David, because I was going to ask if this process or this case leads to the principle of negotiating extensions, right? And not taking the strict position that, oh, you're in breach, life is over, and we have all these rights as a seller. So that was going to be my next question: is does this constitute sort of lead into the conversation of, are parties, bound to work together and really work through some of these extensions to solve these issues?
Yeah, it definitely affects it in my mind, in my legal mind, how I want to negotiate an extension, even if I'm on the innocent party side of this, like in this one that I was just talking about. So originally, like our client says, okay, well, I'm prepared to extend, but we want an additional deposit. We want a release of the deposit held by the broker. We want to pay for all our costs because we're carrying a mortgage and a bridge loan and insurance costs and all that. So so we put all that together. And then the other side balks at, well, we can't give you as much of an additional deposit as you want, and we're not sure we want the initial deposit being released to you right away by the broker. Like there's no prejudice to you because if we default on the extension closing date, you still have the same rights. You can still get that released to you. So I sat down with one of our associate lawyers on this to discuss this. You know what? Like it's probably reasonable for us to give in a little bit on a couple of these points because there isn't really a prejudice to our client. If they close on the extension date, new date, great. If they don't, and this goes to court, we have evidence of a back and forth negotiation that we were acting in good faith to come to reasonable terms, as opposed to no, we were just hammering them with onerous terms that they couldn't meet, and because they couldn't meet it, we pulled the plug on the transaction. So I think we have to, as lawyers, look at this a little bit differently and make sure that whatever we're doing for even our innocent client, there's some element of give and take and acting in good faith on it and not just hammering them.
Yeah, and I think that's important. It's an important message to our industry. It's an important message to other lawyers. And there's this whole concept of working together towards a successful transaction, even if something gets tough along the way.
Yeah. And my role as a lawyer on a transaction is to protect my client. But I'll argue till the end of time that I'm best serving my client in most instances by finding a way to get the transaction closed.
1000%.
Even with a buyer that that they couldn't even, in this particular case, they couldn't even show us they had a mortgage commitment. So it's different. If they have a mortgage commitment, says yeah, we need a week, and the lenders confirm yeah, we can close a week. No, that's sort of easier. Here we didn't even have a mortgage commitment, but it still made sense to try and give them some time to get their act together, as opposed to just pulling the plug and listing it in a down market and selling to someone else and hoping, well, if we don't close, we can just sue them for damages. Well, you never know you're going to have an ability to pay those damages, or you can recover that. And that's a long, expensive process, even if you're the innocent party. So I'm always of the view where we serve our clients best if we explore every opportunity to try and get a transaction closed.
Yeah. And David, I love the way you write your extension letters. You basically write, we have taken the following legal stance. We reserve all our rights. We're going to take your firstborn. However, in a spirit of moving this along, if you agree to the following, we'll work with you. Right. And that's a great legal
Right.
position to stand, because it shows the other side what the law is if they default. And we all know that the courts have consistently ruled against the defaulting party. However, you're also showing the spirit of good faith, where you're giving them options and you're working with them to try to bring this to a successful close.
Right. And we throw in there is without prejudice to our rights. So we're saying exactly what you said, David. You're in breach. We can take your firstborn. We have certain legal rights against you, but so we're taking that position. However, without prejudice to those rights, we're prepared to extend on certain terms and conditions, and let's try and negotiate something in good faith to see if we could work it out. If we terminate the transaction and we take that strict legal position, I'm always encouraging the lawyers in my office to still communicate with the other lawyer to say, hey, yeah, we terminated, we have no choice here, and we're going to list it and everything, but if you get your act together and you get your mortgage funding, let us know. Because before, and I even tell them before we sell to somebody, if we have an offer to sell to a third party, before we actually accept that, I might go back to that first buyer and the buyer's lawyer and say, hey, did you get your act together? Because if you do, it might be a faster closing at a price that our client's still happy with to still resurrect that transaction. And if we can put that back together than just going to the next buyer. So I think we've got to keep those concepts open because bottom line, David, like we're trying to get the transaction closed for our mutual client, right? And the agent's involvement in this is always really critical, telling us, giving us information, what's going on in the market. Are we likely to sell to somebody else? What's our price going to be if we sell to the next buyer? What's the market like? Is it dead? Are we getting showings? There's so much information that we need from the real estate agent too in order to make those proper decisions. So again, it's the teamwork of lawyer and agent helping us through this transition.
Yeah, David, I think you touched on such an important point. I'm going to say this again for everybody listening. So if there's a breached party that cannot complete a transaction, when the property goes to the market, David Corman's office recommends that you put in a subsequently accepted APS, put a condition on there in favor of the seller, going back to the first offer and giving them an opportunity to renegotiate and come back to a transaction. Because what that avoids, if there's a big discrepancy in price between the first offer and the subsequently accepted offer, it alleviates the fact of going through a whole litigation and a court system to bring those damages and reimburse the seller. So I love that concept. I think it's absolutely genius. I think it creates a whole 360 loop where acting in good faith, you're trying to give that first party as much time as possible, and if they still say no at that point, your case becomes so much stronger. And now you've demonstrated that you've gone over and above. You've given them multiple opportunities. You've negotiated with them. You've granted extensions. You've negotiated through subsequent extensions. And even before accepting a subsequent agreement of purchase and sale that's lower, you're still giving them an opportunity to come back to the table and relive the initial deal. It's fantastic. And I think, if that sort of case goes in front of the courts, then the judge would look at the case and say, oh my God, like, you took the concept of acting in good faith to a whole different level. And this is a slam dunk case. And I don't even have to really look at this in too much detail. I'm awarding full damages to the injured party. So I think it takes this concept and it creates a whole 360 and really closes in the loop. And the other thing it does, David, is people are going to stop going through court, right? If they see that, 50 of these cases went to court, there's really no defense for breach of contract. Courts have consistently ruled for the injured party. At the end of the day, buyers are going to say, well, why am I not closing? Why am I, not fulfilling my contractual obligation? I have to do whatever I can, be it sell my house at a lower price, be it pay a higher mortgage, borrow money. I need to do whatever I need to do to make sure that I fulfill my contractual obligations. And what it does is it adds trust and stability to the system. We're so fortunate to have such a structured MLS system, to have such a structured conveyance system, to have such a structured way that we buy and sell real estate. And I think, this whole concept of acting in good faith and the way that the courts have ruled in these court cases adds a lot of confidence to the system.
Yeah, it does. And they aren't conflicting principles when you're relying on the time is of the essence and good faith. They're not really in conflict with each other. They work together hand in hand because you have certain rights created by the contractual language. On the other hand, the facts do matter and your conduct does matter, and you still have to act honestly and in good faith or you lose those contractual rights. So I think the courts are interpreting these things properly. I think us in the industry are recognizing that. And like you said, David, this will create people not having more legal decisions with judgments at the end of the day, even if there's a dispute and parties lay out their position to the other side and can demonstrate that they acted not only in accordance with their contract, but then they also took steps to act in good faith. That's going to push parties to settle. So you're not going to get judgments at the end of the day. So even though there's lots of stuff pending in courts right now with defaulting transactions that didn't go through, most of them will settle, because when the lawyers actually sit down and look at the facts and look at the arguments here, it's easier to figure out that this doesn't have to, but they know what the judgment's going to be at the end of the day. So that's incentive to settle and get rid of it, and don't wait to get hammered by a judge.
And by settling, I mean, I'm hopeful that the buyer or the party in breach realizes that, they have a legal and a principal obligation to move forward the transaction, right? So, I don't want people to use this as an excuse to renegotiate price or anything like that. It has to be the strict performance of the contract that we're aiming towards in its entirety. And I think that's going to give confidence to the system.
Yeah. And we just have to be mindful of the board's position. Like in this particular case, like they put language right into their decision that said, that there was a duty to cooperate and attempt to complete the transaction in good faith. And here there was a delay that was out of the control of the buyer, because of pandemic issues and bank issues and stuff like that. And that should not be pounced upon, is what the judgment said, by the seller in that situation to take advantage of it. Yeah. So, and we're on both sides of these transactions. We're acting for the innocent side sometimes we're acting, but the same concept, same principles apply, and we have to be mindful of them to try and get these things, the transactions closed, which is always the number one interest for our clients, right?
Absolutely. David Korman, thank you so much. This has been amazing. The message is clear to our industry. Work together and make sure that we're working towards closing these transactions together. Thank you, everybody. Join us next time on our episodes. We're going to talk about another really interesting legal issues as it affects the deposits and brokerages.